So a state's attempt to completely ban the purchase and possession of body armor and then try to block the lawsuit against it was just struck down. Now, really quick before we jump into this video, I want to ask you guys for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support this channel, one of the best ways to do that is to simply subscribe and then also click the notification bell, turn on all notifications, because that is one way to ensure that when I release videos, YouTube will actually send it to you. As I mentioned in the intro, in this video, we're going to be talking about the state of New York and their law, which completely bans the sale and possession of body armor within the state. This law in New York was passed in direct response to the Supreme Court issuing a 6-3 decision in Bruin, and then in response to this law, individual plaintiffs in the FPC sued the state of New York. The argument was that this law is a clear violation of the Second Amendment and also Supreme Court precedent that they just issued in Bruin. In response to this lawsuit, the state of New York then tried to have the entire case thrown out early. They filed a motion to dismiss because they did not want this case moving towards a hearing and an actual merits hearing happening in this case, where the court would then look at the context of the Second Amendment and see if this body armor ban did in fact violate the Second Amendment. However, we just received an order from the court here that they have denied the state of New York and their attempt to have this case thrown out at an early stage. Instead, the court agreed that the plaintiffs here have brought a valid challenge to the state law and that potentially it does violate the Second Amendment, and therefore this case must move forward. And in this order, there was some very important language that the court here is signaling that they agree that this body armor ban does violate the Second Amendment. Now, this case arises out of the state of New York passing a law in direct response to the Supreme Court issuing a decision, a 6-3 decision in New York State Rifle and Pistol Association versus Bruin. In Bruin, the Supreme Court struck down the state's may issue CCW licensing scheme, and they found that it was inconsistent with the text, history, and tradition of the Second Amendment. However, in response to Bruin, just days and weeks following that, the state of New York passed even more sweeping gun control laws, an even more restrictive concealed carry law, and then also this comprehensive ban on body armor. New York now bans the purchase of body armor, which the state broadly defines as any product that is a personal protective body covering intended to protect against gunfire, regardless of whether such a product is to be worn alone or is sold as a complement to another product or garment. Under New York law, a person is guilty of the unlawful purchase of body armor when not being engaged or employed in an eligible profession. They knowingly purchase or take possession of body armor. The unlawful purchase of body armor is a Class A misdemeanor for the first offense and then a Class E felony for any subsequent offense. The law in New York also criminalizes the sale of body armor to anyone other than exempt individual. So essentially, you cannot sell body armor to anyone other than law enforcement or other exempt individuals. This law in New York was challenged by various plaintiffs on the basis that it does in fact violate the Second Amendment. In their lawsuit, the plaintiffs argue that body armor is a purely defensive class of arms as opposed to the inherent dual-use nature of projectile weapons. As such, up to and including the present day, body armor remains extremely popular among Americans. This is because, in part, body armor can be employed in a variety of situations. For example, they state, a parent concerned about the safety of their child can buy body armor and then put it in the child's backpack, which is a passive form of protection. They argue in their lawsuit that body armor is an arm for the purpose of the text of the Second Amendment, and therefore the possession, sale, and use of body armor is protected conduct that the state cannot ban. They also argue that there is a long history and tradition within the US for keeping and bearing body armor and other type of armor. They argue that the tradition of keeping and bearing armor has a long and rich history in America, which spans from early European explorers having heavy reliance on armor through colonial era mandates requiring able-bodied men and municipalities to keep body armor ready at hand, and all the way to the mass market of bulletproof garments that have now been used not just in eras like the Civil War and the Civil Era, but continue to be used and be present in the market today where individuals are choosing to buy those. They argue in essence, Americans have always used armor when the benefits outweigh the burdens with very little regulation. They also point out that the Supreme Court precedent under Heller and Bruin also expressly state that self-defense is at the core of the right and that no item meets that type of core definition of self-defense more than body armor. The entire purpose of body armor is to passively defend your life. In fact, they say that Scalia and Heller and Thomas and Bruin both stated historically that there was a definition, and there's a clear definition, that arms are anything that someone can also wear for their own passive defense or armors of defense. Now, in response to this lawsuit, the state of New York then tried to weasel their way out of the case by filing a motion to dismiss. They claimed that the plaintiffs here did not have standing to bring the lawsuit, and they also argued that the defendants here named in the case were not the proper defendants, and therefore the case should be thrown out without actually going to a hearing. New York was hoping to have the case thrown out so they did not have to address the merits of the Second Amendment claims. However, the district court, like I mentioned, just issued a significant ruling, and they have dismissed that. They denied that motion to dismiss. They ruled against the state of New York, and this case is going to proceed forward. In the order, the judge stated that here plaintiffs have demonstrated injury in fact. They allege an intention to engage in a course of conduct arguably protected by the Second Amendment, but prescribed by New York law. Specifically, individual plaintiffs intend to exercise their right to keep and bear body armor for lawful purposes. And because of challenged restrictions, they are unable to purchase body armor in New York. Plaintiffs also allege a credible threat of future enforcement. Specifically, they allege that the Attorney General is responsible for enforcing the New York restriction on the sale of body armor under the general business law. The judge went on to find that the plaintiffs also satisfy their causation and redressability requirements for the permanent injunction. The judge found that their injuries are fairly traceable to the challenge restrictions and can be redressed by their request for a relief, a declaration that the provisions are unconstitutional, and an injunction that would enjoin the enforcement of this law. The judge also found that the plaintiffs made proper claims that because of these challenge restrictions, there is a complete elimination of the market, that no one is willing to sell these types of items because clearly it would violate the law, and then they would be hit with a misdemeanor and then also potentially a Class E felony after that. And the judge did find that the plaintiffs therefore cannot obtain full relief if they cannot get a permanent injunction against this law. The judge here concluded the order by stating that here plaintiffs seek prospective injunctive relief, and the Attorney General has a sufficient connection with the enforcement of the New York general business law. And because she is responsible for enforcing the law, and here she has made statements saying that she would enforce this law in fact, and she has a willingness to exercise that duty. And based on that, the judge denied the state of New York's request for a motion to dismiss, and the case will now move forward towards a hearing on the merits of the Second Amendment. So this is a huge win, not only because the judge actually denied the state's request to dismiss the case and to have the case thrown out, but also there are a ton of hints within this order that the judge does agree with the plaintiffs and believes that this is a valid 2A argument, and that they are clearly being injured by the enforcement of this unconstitutional law, and that potentially there is in fact interest in striking this down completely. Ultimately, time will tell whether or not this judge will actually rule in our favor on the merits of this case, but this is a good sign. There was some good language within this order, essentially leaning in favor of the plaintiffs, finding that there potentially is an injury of the Second Amendment, that this law is violating the Second Amendment and therefore it needs to be blocked, and that this entire ban on body armor is unconstitutional. So again, a solid win in the body armor case. We'll see as this develops what the judge ultimately decides to do. And if we get new information, if anything else develops, I will let you guys know. So if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.